Well, without further ado, then let me introduce Professor Grimmelmann. James Grimmelmann is the Tessler Family Professor of Digital and Information Law at Cornell Tech and Cornell Law School. He studies how laws regulating software affect freedom, wealth, and power. He helps lawyers and technologists understand each other, applying ideas from computer science to problems in law and vice versa. He is the author of the casebook, Internet Law, Cases and Problems. This is actually the last print version. Now it's online only because it's updated every year. Thank you for that, by the way. And of over 50 scholarly articles and essays on digital copyright, content moderation, search engine regulation, online governance, privacy on social networks, and other topics in computer and internet law. He holds a Juris Doctorate from Yale Law School and a Bachelor of Arts in Computer Science from Harvard College. Before law school, he worked as a programmer for Microsoft. After graduation, he clerked for a federal appellate judge. He's an affiliated fellow of the Yale Information Society Project, and he previously taught at New York Law School, Georgetown, and the University of Maryland. He has written for Slate, Salon, Wired, Ars Technica, and Publishers Weekly. He's a regular source of expert commentary for major news media, including the New York Times, the Wall Street Journal, the Washington Post, and All Things Considered. He and his students created the Public Index website to inform the public about the Google Books settlement. Professor Grimmelmann is uniquely situated to bridge the gap between law and technology, and we are very excited to have him here with us today. So with that, James, thanks for joining us. Over to you.
All right, thank you for having me. Thank you for joining me here today. And I am going to share some slides to talk about what internet law is and how I form my own sense of what the subject is and how we should teach it. So, as you mentioned, I am the author of Internet Law, Cases and Problems, now in its 13th edition. And in some ways, this talk is the story of how I came to write a casebook and how I decide every year what belongs in it, because the book has grown from about 400 pages to about 700, and I'm now literally up against the limits of what the print-on-demand platform can handle. So I have to make hard choices about what's in the subject and what's out. And I also only have 28 classes a semester. So there's a constant struggle to say what the subject consists of and what's important for students to know. So my timeline is that I did not think about law school until after a couple of years of being a programmer. I got my degree in computer science in 1999, promptly went to work as a programmer at Microsoft, and then had a very early career crisis that kind of coincided with the dot-com crash. I was working on a very expensive canceled project, and the sense that everything I'd been doing for a year was just going to be thrown away because Microsoft couldn't figure out a way to make it viable was somewhat dispiriting. And I also noticed I didn't want to be a programmer full-time. So I went back to law school with the idea of combining technology with law. That stuck, and I've been teaching and writing about law and technology since the mid-2000s. The casebook came about basically because existing books weren't updated frequently enough for me to teach them effectively. I started teaching from a book in 2007, and the next year I had to supplement it with a few cases because they'd happened and it wasn't a new edition yet. The year after that, there were so many new cases that the volume of new material outweighed the volume of existing material I could use from the casebook. And within a few years, just the packet of materials that I gave my students every year had swelled to the point that I realized I might as well publish it. And since then, the casebook has basically taken shape every year as an outgrowth of what I need to teach. And so in some ways, this timeline puts me in the middle of what I think of as the second era of what this subject consists of. So I mostly want to talk about sort of a historical sense of what people would have taught in a course that was internet law or its equivalent at various points over the last 40 years. So if you went to law school in the 1980s, your law school probably did not have a course on internet law. It almost certainly didn't, because the internet was not a subject that was worth covering. It also probably didn't have a course on computer law. A few did, and it was taught by a few specialists who were interested in the field or had experience working with technology companies themselves as practicing lawyers. And it was very much a subject that served a small specialist bar who worked with technology companies. And so there's a bunch of very important nuts and bolts, like what kinds of IP protections are available for hardware and software? How would you license that IP? How would you do deals to commission computer systems or develop things? And where would liability rest in cases where a system failed to function as it was supposed to? And that could be tort, or it could be defective products, sometimes contract liability. But it was very practitioner focused. In some ways, it resembles what entertainment law or sports law would be today. It's the collection of topics people who are working with a particular set of clients need to know. Well, things changed in the 1990s. That's the decade that the internet became massively popular thanks to the web. So it explodes into mass public consciousness. And there are also a whole bunch of developments that give people a sense there's something really important here. 1996 is just an incredibly crucial year in the legal academy sense that this field is its own thing. John Perry Barlow's Declaration of the Independence of Cyberspace is in 1996, and that's the protest against the anti-pornography provisions that were bundled into the 1986 Telecommunications Act. But that's also what gave us the regulatory structure the internet is still working under. 1996 is also the year of a famous conference at Stanford on law of cyberspace. And that gave us a bunch of pretty memorable articles, including one by David Johnson and David Post called Law and Borders, that makes a more academic case that the internet is its own jurisdiction and should have its own laws. This is also, within a couple of years, we get the Digital Millennium Copyright Act, which gives us the main framework for online copyright liability. It gives us the anti-circumvention provisions that lock down DRM. And 1999 is the year that Larry Lessig publishes Code, which is like the book that brought the field together and brought it into public consciousness. That was actually my entry point into this. I had been in college through the decade. I read Code in 1999 as a programmer, and it opened my eyes to the fact that the legal scholars were actually saying something interesting about this. So you have all of these within a very short span of years, and they lead to the idea of a course that would be focused on what's called cyberspace. And this would be law for space that's different than the offline world. Maybe it's just somewhere else. Maybe it obeys very different laws of physics. That's the idea of Barlow's law. He's like arguing that cyberspace isn't a place that offline governments can control at all. And this leads to an explosion of new legal topics. You have jurisdiction because there are fundamental questions about whether governments can control what happens online at all, or if they can, which governments have a right to regulate different online conduct. There's free speech. Barlow pushes this idea that what happens online is pure speech, and therefore it's completely unregulable. Everything we do online is just speech and not conduct, and therefore governments should stay away. You have privacy, copyright, the first major hacking attacks that are in wide public consciousness. And there's a sense that all of this is a called a new kind of law for a new place. It's also a time when the legal academy has a bunch of scholars who are still active today who are really leading and defining this field. So Pam Samuelson had been active back into the 1980s on software law, but Pam Samuelson and Larry Lessig and Mark Lemley, people like this really play a major role in defining what this field is going to look like. And that's basically the casebooks that were dominated the field when I started teaching come from this era. And there's an orientation towards this vision of, do we need laws for a new place. This is also a time when you've got a whole bunch of very high-profile legal fights over what seem like truly fundamental issues about what the internet is going to look like. And all of these have pretty much the same orientation. It seems like there is one set of positions that are the internet is inherently free and shouldn't be regulated. And on the other hand, there are governments and copyright owners and other groups trying to lock down the internet and restrict public freedoms. So you have jurisdictional fights. The French government tries to make Yahoo remove Nazi memorabilia from its auctions. And Yahoo initially says, we're not in France. You can't do this to us. So you have jurisdictional fights where people say, we are doing business from someplace else. You can't reach out to us just because our website's available on the internet. There are major copyright disputes. So you get the peer-to-peer file sharing fights over Napster and then its decentralized successors. Those culminate in 2005 with the Supreme Court's Grokster decision. You have fights over breaking DRM and digital locks on content, the most famous of which is the fight over DCSS, which strips encryption from DVDs. You have slightly later the fights over whether YouTube and other user-generated content sites are going to be liable for user-uploaded material that infringes. And the DMCA creates the safe harbor that says no, provided you respond to takedowns. But it's not really settled until the mid-late 2000s that the safe harbor is actually going to work at the scale of something like YouTube. You have a bunch of free speech fights. The Communications Decency Act of 1996 involved an attempt to hold websites liable for indecent to minors material that's accessible to minors. Supreme Court says this is unconstitutional, but there's a couple of follow-ons that take up most of the rest of the 90s. And then you have fights over unauthorized access to computer systems. Intel versus Hamidi is really the famous case here. The Supreme Court of California holds in 2003 that an ex-employee can't be liable for sending a lot of emails to Intel employees. This isn't a trespass on their systems. And I think for a large number of people who were there and lived through this, these fundamentally shaped their sense of what internet law is about. It's about these big fights between openness and control. And a lot of people saw themselves as being, having to be vigilant on the side of openness. I had the experience of basically being in college and law school when this was happening. I was aware that it was, but a lot of it didn't settle down by the time I started working. And so I have this maybe different orientation towards the subject than some of my elders. At the same time as you have these very high-profile policy fights, there's another way of teaching the subject that is in vogue for a while. And you can call it roughly e-commerce. And this is an updated version of the computer law practice area approach. The difference is that now the internet is part of it. And there are also many, many more people who are interested in it. Many more companies are technology companies. Many more clients have internet issues. And so there's seen as a broad demand for the professional skills for the lawyers who are working with them. So now you have to worry about jurisdiction because your company might be doing business and there's multiple regulations. You have much more privacy compliance law to deal with because you have things like the EU's data protection directive. You have various US state laws on privacy, lots of online contract formation. Intermediary liability becomes a big concern because you need to know when you have to take action on complaints about material on your systems. And then a specialized practice around rights to domain names that's heavily focused on trademark law. Now, lots of law students still go through law school having zero contact with any of this. But it's now a major practice area that many law firms have. It becomes a thing you could go to law school and say, I'm going to do this as a career. And so there's a pretty clear set of skills that people feel they need to have. And the e-commerce vision is sometimes associated with the closed and locked down side in the policy wars, but often it's just a technocratic, I'm not going to pay attention to the big debates, I'm going to help clients with day-to-day work. So what I think of as internet law and what the book covers is in some sense the fusion of the cyberspace debates with the e-commerce ones. The actual vision of the internet as cyberspace, a place that looks like the Matrix or like Tron, where we go online and we're not in the offline world anymore, that looks really stale now. There's not as much of a sense that we're going someplace else and we're leaving our offline lives behind. So in some ways, I think we've rejected that vision in favor of one where what happens online very much affects what happens offline, and people have online lives that are extensions of their real world lives. But the big policy questions are still very much live. There are still pretty significant questions about the extent to which governments do control what happens online, the extent to which First Amendment applies. These issues didn't go away. They just got transposed into a more ordinary register of we're having legal debates over legal issues, rather than being some existential question of the internet as a complete transformation of how humanity exists. So I think this is a pretty coherent subject. It draws on the practical day-to-day skills, but it touches on big issues. It's the set of topics as kind of the union of the cyberspace policy ones with the nuts and bolts of e-commerce. I think it's a pretty coherent subject, both to teach and write in. But what's pretty interesting about the community, you see, is there aren't actually that many internet law scholars as such. I identify myself as one. There are a bunch of other people who do, but it's much more common for people who are teaching and writing about the subject to identify with some other field that's more traditionally defined by an area of law. So you have IP scholars, people who do copyrights or patents, whose writing hits on internet topics. The privacy community has a bunch of people who do online privacy. You have telecom scholars who then deal with the content layer in addition to the network regulation. And all of these people work on internet issues. Their work is in dialogue with each other, but it's still not as common to be an internet law scholar well into the 2010s. At the same time, the idea that this is a separate field that doesn't touch the rest of law is kind of collapsing. People who teach in bread and butter subjects in other parts of the curriculum have internet issues and internet cases in what they teach. So you find property case books with cases about online resources and who owns a domain name or what it means to use a computer system. You have contracts cases in the first year curriculum about online contracting. You have questions about digital evidence in the evidence class. And this is mirrored in legal practice. Lots of people who are doing something like family law now have to get at least some internet training, because if they have to deal with a custody case, the evidence may be stored in digital accounts and they need to know how to acquire that evidence and introduce it. And so it winds up touching more areas of law, but being kind of invisible when it does. It's just a subject matter that all lawyers have to be at least a little bit familiar with. Now, what has happened in the last few years is that I've had increasing trouble saying this is the core content of the book. That I resisted for a while the idea that, oh, I have to cover something like drones or robots. Like, that's technology, but how is it an internet issue? But people would come to me and say, well, this seems related to me. I want to teach it as part of my course. And I've had to struggle with that definitional question with a lot of things that people now see as related to internet law. So I'm starting to wonder whether the consensus core of what the field covers is unraveling or maybe changing a bit. And there are maybe 4 trends of the last 5 years that really potentially upend what I teach. The first is that the big tech platforms have become increasingly important. It used to be that I would have a Facebook case and a Twitter case and a couple of YouTube cases. But now I find that an increasing fraction of the new material I put in the book with each edition focuses on the regulation of these big platforms or how they deal with user-posted content. I had to add a couple of sections on content moderation just because it is so much of what people argue about and where the legal disputes arise now. You also have a revitalization of interest in antitrust, in e-commerce platforms, and how they can be held liable for user-posted material, so like your Airbnb or your Uber. That platform-based material is increasingly central to what the course covers. That there's a sense in which internet law is about the things that happen on these platforms as much as anything else. The second trend, which is really in the last 2 or 3 years, is that all of those policy fights that I mentioned back in the 1990s have returned, and they are really seriously here. So there was a time when it seemed like intermediary liability was very much a settled question. Section 230 of the Communications Decency Act said that sites are not liable for harmful user-posted content. If it's defamatory or invades somebody's privacy or harassing, that's not the platform's responsibility. There is now a big constituency that wants to undo that consensus. It contains people both on the right and the left who are very critical of big tech platforms and want tools to rein them in. This has led the Supreme Court to take a Section 230 case this past term. It ducked the issue, this was in the Gonzalez case, by deciding there was no liability on the substance of the claims, but there's interest in opening that debate up again. The same thing is true with fights over jurisdiction. You have countries around the world trying to exert control over the major tech platforms. This is absolutely the case you see in China and India, but you also see many other countries doing the same thing. And even United States are trying to push strong privacy laws or what they see as children protection laws. And we have big unsettled issues about the extent to which these state laws can be enforced against national and international companies. Copyright fights are back thanks to generative AI. You've got a dozen lawsuits against AI companies. And you even have some of the same debates around whether platforms have to carry content. Network neutrality is back yet again with a new rulemaking to reinstate it after a period when it was repealed during the Trump administration. And we have similar fights now at the platform layer. State laws in Texas and Florida that would force platforms to carry almost all user-posted content are being challenged before the Supreme Court this term. So in some ways, it looks very much like a replay of all of the big fights that we had back in the 90s. The third thing is, this very much this past year, that generative AI is a huge question mark hanging over a lot of the subjects that are part of internet law. If you'd asked me how to classify it in terms of legal fields, until about a year ago, I would have said, oh yeah, it's part of privacy law and tort law. Those are the areas where AI for decision-making can have serious effects. Use of AI could involve profiling people, and then the decisions you make could discriminate against them. So yeah, it belongs to the people who are working in privacy and tort regulation. Generative AI is a lot broader because you can use these tools to give medical advice or to generate novels. You've now pulled in pretty much everything in intellectual property as potentially relevant there. It has huge effects on labor and employment. This is a big part of the Writers Guild strike this summer. The actors had a similar set of issues around the use of generative AI avatars of them. So we don't know what it's going to do to all of these areas yet, but it could potentially scramble a lot of them. And that's going to lead to, potentially changes, throughout every part of the book. And then finally, there was a big blockchain boom. And for a while, people were talking about blockchains and Web3 as the next big thing that would require re-regulation or rethinking of all law. I don't know if that's going to happen. I am increasingly skeptical. I had a section on blockchains in my casebook. It's still there. I'm not taking it out. But at least in the short term, I don't see it growing much. I need something else to happen to justify more coverage. And if I had to put a fifth wild card on here, I'd say, well, metaverse, is that going to happen? We've had these debates twice before. We had the cyberspace debates in the 1990s, and we had a brief flourishing of virtual worlds, as they were called, in the early 2000s. There were conferences about what law would apply to Second Life or World of Warcraft. And that kind of ebbed away for a while. Facebook is trying to make the metaverse a thing. Apple's Vision Pro is about to ship. I don't see it leading to a full replay of the original claims that cyberspace would be a separate place, but it could be that the sense of three-dimensional real presence leads us to think about some issues at least a little bit differently. So I have my eye on that. And as a casebook author and a teacher, what I worry about is there a coherent core here? At some point, does this dissolve back into a collection of unrelated topics? This was the critique that Frank Easterbrook made of cyberspace law in the 1990s. It's the law of the horse. Cases about people kicked by horses, cases about the sales of horses. But there are no there's no law school field of horse law because it's just learn some contract law, learn some tort law. At some point, does internet law become so pervasive in law that is no point in studying it as a separate thing? Is it just devolved into a separate set of topics that get covered all throughout law and all throughout legal practice? I don't think so. I mean, my whole casebook is built on a rejection of the idea of the law of the horse. I think Easterbrook was wrong. But if I had to predict where the core is going to be 5 or 10 years from now, I think it's going to be about platforms more than anything else. And AI might fit into that as a set of platforms. If blockchains come back, there'll be more platforms too. That might be where the heart of the subject is. I haven't firmly committed my book to that. I have a platforms chapter, and I'm keeping my eye on it, but I don't think the center of gravity has shifted yet. But that's one of the fun things about working in this field. There's literally news every day that is relevant. And I got into this because I thought I would never get bored, and I haven't. So I've enjoyed very much writing and teaching about internet law. And I'd be happy now to have a bit of a conversation about where we think the field is going, what it consists of, and what the interesting issues to keep our eyes on are.
So I guess we can start with a question typed in by Rebecca Lively. Have you read Software by Space Force Major Jason Lowry? His central thesis is that Bitcoin will be key to authentication / zero trust in future nation-state conflicts. It's an interesting thesis made more interesting by the fact that the Department of Defense required him to stop making it publicly available.
So I have not read it. I guess I'm skeptical about the idea that blockchains in particular are going to be central to future nation-state conflicts. I think that cryptographic security and authentication are incredibly important, and that control over authentication infrastructures is an important domain of security and conflict. I'm not sure that I see that blockchain in particular is going to be the center where that happens.
You mentioned cryptographic security, and I wonder, with things like quantum computing possibly on the horizon that can make quick work of encryption that currently exists, have you seen any discussion on how the body of law can address the problems that may arise if all of a sudden the things that we thought could be encrypted for 25 years can only be encrypted for a month?
So I gave actually this as a final exam question in my internet law class last year. I gave a question that was essentially, you're working for the computer crime section at the DOJ, and you have just received information about a site that seems to be selling cracks of a commonly used encryption algorithm. And the key thing to recognize was that whoever has done this has just broken the encryption on which most of the internet relies. So you have a bunch of open, smaller issues like forged emails and some snooping on SSL communications, but you have a much bigger security crisis here unfolding. And yeah, I don't know if there's a ton of law that hinges on this, but on practical terms, so many different applications depend upon the same set of cryptographic basics. It's kind of stunning. We have privacy, we have authentication of transactions and emails. We've got a lot. Even the ability to connect reliably to a website depends upon this. And I think one of the things we're kind of lucky about is that the rise of quantum computing has been a very slowly unfolding thing. The hardware difficulties of making systems that use qubits effectively have been hard enough that we've had a long runway to say, okay, some of these algorithms are going to be highly vulnerable if we have efficient factoring. Therefore, we need post-quantum algorithms to replace them. And we've had the time to have a pretty orderly process for vetting candidate algorithms, making sure that they are secure against both classical and quantum attacks. So I think, if I had to guess, that we're going to have a more or less orderly changeover in advance of the time when quantum attacks become really feasible. So I suspect it will be a fairly small impact, but it will be one of these things like Y2K, where it was in fact the anticipation and engineering effort that made it into a non-crisis when it arrived.
Yeah. Now I'm going to address our attendees really quick. You are welcome to type questions into the question box down at the bottom of your screen. If you want to raise your hand, there's a little raise hand button. I can also allow you to speak if you want to verbally address a question to Mr. Grimmelmann. If you get tired of my questions, feel free to jump in. I will go ahead and ask a couple of questions in the meantime. First off, how much are our online lives affected by laws in other states or countries? For example, you mentioned the European Union data protection laws.
Yeah, and so it's interesting. Some platforms very much use a least common denominator approach to global compliance. That once they have to build tools for give me my data, delete my data, or forget about me, they'll just roll them out worldwide. And so there's a certain degree to which, yeah, you can download your data and take it with you because that's a portability requirement in the EU. It's also just considered now best business practice in a lot of settings. In other places, there's companies have decided instead to do geographically based blocking. So the content will still be on the platform, but it won't be available in Turkey or Brazil or in Russia. And they will just filter that jurisdiction by jurisdiction. This is easier at the country level than at the state level, but I'm a lot of platforms, I think, are looking into it in light of the possibility they have to do state-by-state compliance. The California data protection law, in particular, has resulted in a division between the rights they give California residents and the rights they give others for a lot of platforms.
How effective are those data filters that are intended to be based on geographic boundaries?
They vary. Some of them are pretty easy to get around. A lot of the content geo blocks can be circumvented with a VPN pretty directly. So there are a lot of people who want to subscribe to the BBC's iPlayer for the shows that haven't made it to the US yet. And they just use a VPN to go and make it like they have an address in the UK so they can subscribe to BBC content. There are other places where they're actually making a more serious effort. And so like Netflix is getting better and better at geo-blocking so you don't get content outside of the zone that you are registered with them in.
Now, having spent a little more than 6 years in total overseas, sometimes US content I may want to access, I can't access without a VPN. Other times, US content is blocked if you're using a VPN. So it's interesting that there are a lot of approaches to that.
Yeah, I have to imagine that, especially dealing with government networks, there's probably a fair degree of pretty careful policing there to make sure that access is coming only from vetted sources.
Yeah, we are very big on two-factor authentication, which is kind of becoming a thing in a lot of parts of the internet. I don't know if you see much reaction to that. How do people tend to feel about how much more secure everything is?
I don't know. I mean, my offhand sense is that things are in general more secure, that while there are still significant hacks against sites that target companies and their databases, the day-to-day, I am who I claim to be, like this really is me accessing the account, is probably better than it has been a lot of times in the last few years. Just the use of phone-based two-factor authentication, the coming rise of passkeys, I think the experience is probably better overall than it has been.
And you mentioned some of the early treatises and ideas about the internet and the openness, and you didn't specifically say anonymity, but that was kind of a big part of the excitement about the internet. Is a lot of that dying as we try to secure against these various hacks and phishing attempts and things that continue to happen?
Yeah, I should have put like anonymity as one of the big policy fights of the 1990s. That this was seen as the Clipper chip wars of the early Clinton administration, in an attempt to basically have all communications be visible to the government going through authenticated standardized encryption. And the fights over the Fourth and Fifth Amendments in terms of when somebody can find out your identity and whether your content can be decrypted, that's one of those things that has never actually gone away. It's been a pretty steady set of controversies throughout this whole period. iPhone unlocking fights, for example, took place during what I would have called one of the quieter periods of internet law in the 2010s. That's always been with us. Yeah, I think that the sense of the internet as a space for really anonymous expression is weaker than it has been in the past. More people have come to see anonymity as a threat for various reasons. You have a national security perspective on that. And you also have an anti-harassment perspective, that people see anonymous actors as able to cause a great deal of damage. There are still a strong community of people who are internet scholars and activists who are pushing back against that because they see anonymity and anonymous expression as a human right. And this is absolutely true when you look at repressive regimes around the world, that there's a sense of, oh yeah, we really do need anonymous expression, or otherwise they can completely squelch dissent.
So this might be a good time to talk about one of kind of the themes in your casebook is this idea that law is not the only pressure that is put on, I guess, the way people act online. You have a dot and you have 4 different influences. Would you mind kind of explaining that?
Yeah, this is a wonderful idea. It comes from Larry Lessig. It's one of the great insights of his work in the 1990s and his book Code, that there are 4, he calls them modalities of regulation that affect what we can do. They're law, social norms, the market, and architecture. And he gives an example like smoking, that you can have a law against smoking indoors. You can have social norms. People will be tell you to snuff it out if you light up inside. You can have taxes on cigarettes that make them more expensive, or you could have architecture that just makes it physically harder to smoke. And changes in architecture can have changes in the referential behavior that are as important as anything law does. So the switch from cigarettes to e-cigarettes is an architectural change that makes a big difference in how and where people smoke. Last, a great insight is that you go online, the internet has an architecture. That's how our websites connected, our communications identified by their sender. What do you have to do in order to connect to a site? All of that is internet architecture, and that shapes our behavior. And that architecture can be changed by reprogramming how websites or platforms or servers work. So the changes in the technical conditions of the internet make big differences in behavior. We have higher bandwidth than we used to. We have better techniques for geolocating where sites are. We have large databases that connect people's behavior across different sites as they get tracked. We have instant replies and social media that let us provide small bits of user-posted content. We have search engines. All of those go into the mix for shaping what people's online experiences as much as formal laws do.
And those kind of interact, one affects another. And so when we talk about law in the internet, it's kind of hard to limit it just to law because there's so much interaction between the law and the architecture and even the norms in the market.
Yeah, it's like when you think about any kind of legal change, you have to ask not just, is this behavior one that we want to stop or not, but how will the market of what companies offer and how users behave shift in response? If you close off this avenue, will they go over there? Or will you develop new technical countermeasures that make things harder? Right now, for example, the deployment of end-to-end encryption in various companies' messaging products is a big part of that story. In order to limit surveillance of their users, WhatsApp and Apple Messaging, and Facebook Messenger, they all have rolled out stronger end-to-end encryption that limits the possibilities for both commercial and governmental surveillance.
Now, I'm going to go back a little bit further, if you don't mind. And you talked about horse law and how the internet, it touches on all kinds of areas of law, from copyright to criminal law to jurisdiction, et cetera, et cetera. Is it fair to say that to be a specialist in internet law, you kind of have to be a generalist?
Yeah, I think that's right, that you have to know a little bit about a lot of things. And I do think that there are, running themes that connect a lot of it. But fundamentally, you have to know a little bit about copyright and a little bit about trademark and a little bit about contract law and a little bit about tort law privacy and a little bit about criminal privacy, criminal procedure. And it winds up being a very long list of topics.
Now, there was a case, I think this kind of goes more to jurisdiction. I believe Google was involved. I think you'll know what I'm talking about, where Canada told Google, you have to do this thing. And Google went to the United States courts and they said, no, you don't have to do this thing. And it became a really interesting kind of case study, and nations' laws kind of pitted against each other. Do you mind explaining a little bit of that? I just think it's a fascinating case study.
Yeah, this is a case study that I give in the jurisdiction part of my book. which is this back and forth between Canada and the United States and Google over a company that had been selling knockoff networking equipment. So they get sued in Canada by a Canadian company, and the defendant doesn't quite default, but comes close to it. And then the plaintiff says, okay, we need to stop them from selling these knockoff devices in Canada. And they get an injunction saying that Google needs to block results for the defendant's website. So Google goes along and complies with this and removes the search results when you search from google.ca. Well, the Canadian plaintiff says this doesn't really help us because people will go and search on google.com. So we need a worldwide removal. Then the Canadian court says, fine, we'll order Google to remove it worldwide. We have jurisdiction over Google. And Google says, whoa, 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 you can't do that. This isn't legal in the United States. And so Google goes to an American court to get the American court to say this injunction is unenforceable here. And the end result of it is that the American court says, yeah, this would violate US law. No, you can't, Google is not required to do this. And then the plaintiffs go back to the Canadian court and Canadian court says, actually, you are. Go ahead and do this. And Google then removes it. Looks like a showdown between US and Canadian courts, and the Canadian courts hold firm and the US blinks. I think actually Google didn't litigate it as aggressively as they could have in the United States to avoid provoking a direct court versus court in battle of injunctions. The motion that Google made in the US court wasn't designed to be an order requiring Google to do anything. It was just meant to be an order that Google could show to the Canadian court to say, hey, this violates US policy. And the Canadian court looked at that order and said, yeah, it might be against US policy, but we're in Canada here, so we're going to stick to Canadian policy. Google didn't actually go to the US court to get the court to say, no, you can't comply with the Canadian one.
And it seems like in the end, whatever foreign countries' courts are at issue tend to win because companies decide, well, I would rather continue to receive the revenue that I get from that country than be kind of shut off from that country. One of the earlier cases was the Yahoo case that you mentioned earlier, where I can't remember if Yahoo itself was selling items that the French government deemed to be unlawful. And the French government said, you have to stop selling these items. And Yahoo said, who are you? I'm an American company. I don't listen to you. And do you mind kind of giving the rest of that story as well?
Yeah, so this is another example of the company ultimately blinking. Yahoo gets the French court initially buys Yahoo's arguments that Yahoo isn't in France and can't be forced to comply. But then the plaintiffs successfully show that not only does Yahoo have some assets in France, it's actually using European servers to target content to French users based upon geolocating them. So Yahoo is trying to get the benefits of the French market by creating content specifically for them, and it has assets in the EU. And at that point, the court says, no, you are French enough for us to enforce this against you. Yahoo then tries to prevent that order from being domesticated in the United States. It goes to the US court system to say, well, we're protected by the First Amendment here. We want you to establish that any attempt to enforce that judgment in the United States will be unenforceable. And they get part of the way down the road towards being able to get the judgment stopped. And then Yahoo gives up because, as you say, they want the French business. And they would rather do business in France on French terms than stick to their very US-based understanding of what free speech law and the First Amendment allow them to do. And that's generally true. More often than not, companies will comply with the local law and do what they have to. Only in rare cases do they pull out of a country rather than comply.
Now, speaking of the First Amendment, and I'm not seeing questions from our attendees. I guess that means that what we're talking about is interesting enough. The United States has a uniquely permissive view of freedom of speech. And this has really come to a head in some cases, such as the Australia defamation case. But this is a bigger deal in the internet than it is probably in any other part of our daily lives, because the internet is so worldwide. How do companies navigate these vastly differing perspectives and nations' laws on freedom of speech?
Generally speaking, they make decisions about which countries they want to do business in and whose laws they take seriously. So a small company based in the US might not think about anything besides US law. After that, they'll typically go to the EU and think about basically EU law as an undifferentiated whole, that they'll comply with the GDPR and with the EU's laws on remote selling, and then they won't go from there to individual countries until they get substantial markets there. And at that point, there's kind of interesting process where they'll say, okay, we need to think about German law and French law. Those are really big markets. And then they won't worry about all of the others. Or they might say, well, we're going to be doing business in Latin America. Okay, we're going to do Brazil because it's big, and we'll do Argentina and Colombia, and we'll get some local expertise in that. And we're just going to assume that all of the other Latin American countries' laws are close enough to those that we won't investigate the details unless something forces us to pay attention to them. It's very much a kind of triage based upon the costs of educating yourself and doing compliance.
All right. It looks like I'm going to get the last question here. I'll give a 5-second pause for any hand raises, but I don't think there are any other questions. Okay, so since I get the last question, I want to go back to the casebook. For a couple of years, I've seen the 10th and the 11th and the 12th and the 13th. Are we on the 13th or the 14th edition now?
I think we're on the 13th. I've lost track now.
Okay. And I see things that you're adding, and I can see, yes, this needs to be added. It seems like it would be much easier to add things as new cases come out and new issues arise and new technologies make themselves prevalent than to decide what to take out of the casebook. But if you never took anything out, the casebook will just burgeon. How do you decide what to take out of the casebook?
So some things I take out because I don't teach them. After a few years of not teaching the patent law material, I decided that it wasn't essential. It just, if I made the decision not to cover it in my limited time every year, it was probably not core material for the casebook. Sometimes I also find that I can take something out because it's been rendered obsolete. When the Supreme Court issued its Van Buren decision on the Computer Fraud and Abuse Act, that just mooted a bunch of the older materials I had in that section, and I was able to pull several cases out. And then the third way I pull stuff out is I find that I can cover it more efficiently. If you look at the edit of the Dow Jones Australia case, for example, I think I've cut paragraphs from that one several times. And then by the time I've sort of been, okay, what I want to say in this section is really confined to this one excerpt. I can focus on that and remove a couple pages from this other part of the case. It's teaching sort of regularly forces me to reread large portions of it. And as I go, I'll say, okay, yeah, that question isn't doing any useful work. I'm going to pull it in the next edition.
Well, no federal endorsement intended here, and this is my own personal opinion, but I really appreciate your case cuts. You do seem to get a whole lot of information in a shorter amount of time than many legal case books I've read. So thank you for that. And thank you for joining us today. It's been very interesting. I apologize for the technical difficulties at the beginning, but I really appreciate you joining us, and I'm sure our attendees also appreciate hearing from you. So thank you very much. Do you have any closing remarks you'd like to make?
Nothing other than thank you for having me. It's been a lot of fun.
Okay, well, thank you, Professor Grimmelmann. Thank you to all of our attendees, and we'll see you in the future. Thanks a lot.
All right. Have a great day, everybody.